What'd you say, Ben?
So last year, last semester for business associations, what I did was go over the student-generated multiple choice, which I found actually worked pretty well for review sessions. So we're going to do that today. I don't know that we're going to get through all of them in the hour. I don't know that we have the ability to stay here much longer than an hour in terms of concentration level, but I can stay as long as you need me. I've got childcare today. So which do you want to start with, your questions or the old questions?
Our questions.
Your questions it is. That would be spring 2009. Okay. Now, it might be a little bit boring, but what I want you to do, I'm assuming you haven't had a whole lot of time to go through them yet. So take your time, read through them. As you read through them, I'll refresh my recollection since I just rewrote these, I think it was Monday. And then we'll talk about why the correct answer is the correct answer.
Are you still just going to narrow it down to a couple? Or
I don't understand the question.
Like the list you gave us, you said you might pick a couple to put on the exam. The ones you posted, are you using all of those or just a couple of them?
Oh, I'll just use some from here. I have specifically not decided which I'm using yet. If you look up when you're done, I'll know. Okay, so what is the correct answer? Shout it out loud and clear. Brave souls, what do you think? Big guess. Give me something to work with.
1 and 2.
So that would be B. That is correct. So everybody understand why 1 and 2 is correct? Ex parte communications are prohibited in formal adjudication and formal rulemaking, not the other forms. And because this was a procedural-based rule, it would not have been subject to notice and comment rulemaking, because that's one of the exemptions under Section 553. By the way, 5 is, I think, nonsense.
Yeah.
So, and I can't remember what I did to change this one. I know I did something, but anyway, all right. So that's about all I can help you with on that one. Anybody have any questions then about ex parte on communications on that one? Now remember, there's a difference between ex parte communications and illegal is the wrong word, but unacceptable or impermissible ex parte communications, right? Just because it's ex parte doesn't make it unacceptable. It has to be specifically prohibited by provision of the APA, which is why ex parte are permissible under informal rulemaking and informal adjudication, unless the agency enacts regulation or Congress enacts statute that requires docketing of some sort or something like that. All right, so question 2. That should be advice. Tammy, what do you think on this one?
B.
B is correct. Due process was a popular one for questions. And this one actually, I don't think I changed this one a huge amount. But I remember I did add something in D regarding Matthews versus Eldridge. Remember, Matthews versus Eldridge, once you've decided there is a deprivation of a property or a liberty interest, then you turn to Matthews versus Eldridge to determine what the procedures are that are required. It's not, we don't look to Matthews versus Eldridge at the deprivation stage. It's after we've determined that a liberty or a property interest is involved. Okay. Question 3. Love this one. You guys obviously have the humor wiped right out of you. That was a funny question. All right, what's the answer?
Not A, not D.
Okay, that's correct so far. Not A and not D. That narrows it down to B, C, or E.
I put E.
E, 2 only? Okay, anybody have a different answer? C, why did you add, so the additional would be that 3, a due process hearing is required because the expulsion would potentially deprive Charlie of a liberty interest. Why did you not add that one? Those of you, C is the correct answer. Why did you not add that one in? I may have changed the answer from the original question, I can't remember. Because does it not seem like a liberty interest? The ability to go to law school is a potential, remember that was just like our problem, is that if you are expelled from school, it's sort of a blot on your reputation. It's going to negatively impact your ability to get into future schools and potentially even get jobs. Yes?
Ron and I thought it was a property interest to go to school.
It could be both. It could potentially be both. You would have to have a property interest, you would have to have some, more than a mere expectation, right? You would have to have something that gives you a right to stay here. And that information actually isn't in the question. There's nothing in there about school rules or school
Like
policies
tuition
or
or something?
contract. And which is why I don't have property interest in the answers. But it can be both. You can have both a property and a liberty interest in the same thing. They're just analyzed differently. Yes?
We did the problem class, didn't we determine that there wasn't a property because we couldn't agree that tuition was enough property, or there
That's state action. The issue on state, the issue with whether it's state action was the issue of whether the fact that you're paying, you have student loans or we accept money from the federal government means it's state action. That's a whole different question that I'm not testing on. That's con law or some other class. What we talked about is the way that you would get a property interest in something is that you have to have something that gives you a legal right to it, whether it's a state law that gives you a legal right or whether it's a contract or an applied contract. Remember the teacher who expected to get tenure because they, or not tenure, but a renewed contract because everybody else got a renewed contract? Yeah.
I was just going to say, like, welfare benefits. You've qualified under the statute.
Under a
So
statute.
you have a right for it.
Right.
So it can't be taken away unilaterally.
Correct.
Would you differentiate between like a college and like a high school setting where there's probably more of an argument that like elementary or high school students are guaranteed to have an education through?
Yeah, I think it's much easier to show that there's a property interest to people, to students attending public schools up through 12th grade because you do have a right as a member of the state. Now, you have to meet the obligations to keep that right going. That's the same thing really with staying in school. You can't cheat and expect to stay in school. But again, the property interest is analyzed differently. If I were to have tested you on the property interest, you would have had information in the question that would have talked about something, some implied contract or some statute giving a right. You can't just have a property interest without having something supporting it. Does that make sense?
And that would be found in the contract, that'd be found in the statute, or found in some kind of program set up by statute? I mean, issues to look for.
Basically, it's either a state statute, a federal statute, or something under state law, state common law for contracts, right? So either a statute or state common law. There's no federal common law in this particular area. So state statute, federal statute, or state common law. So under state common law, you can get both written contracts and implied contracts. I can't think of anything other than those. You know, maybe if there was a regulation and saying that you were entitled to something, you could count that as well, a federal or a state regulation giving somebody a right. But there has to be something else granting you that right. And usually I'm going to put that in the facts. I'm not going to expect you to know what that is. But this one was so much like the one that we did. I could potentially have said that this will impact his ability to go to future law schools. Maybe that would have made it clearer to you. But I think because it was so similar to what we had done, that I didn't necessarily think it was necessary. Hold on. Okay, question 4. Well, gee, who wrote this one? Okay, what do you think on this one?
It's either,
I'm sorry?
it's a policy, I haven't looked at the answer choices, but it's a policy statement, right? So it doesn't need to undergo.
Why do you think it's a policy statement?
It's,
Because
the
it
language.
says so, doesn't it?
Well, yeah, the language said, policy. Well,
Yeah,
something
never,
like
never listen to what the language says. Do your analysis.
Okay.
A policy statement is what? I mean, this is actually, I'm glad
A
you did.
non-legislative rule.
A non-legislative rule.
That doesn't need to undergo any kind of rulemaking procedures that has future effect.
Right, but what's our test for whether it's a legitimate policy statement or it's something that should have gone through notice and comment rulemaking? Binding norm. What we're looking for here is the idea of, is this something that allows the agency flexibility to change its mind, right, in the future? Is it creating existing duties now? So that's policy statement. What is the other form of a non-legislative rule? Interpretive rule. So it could potentially be that as well. Is it a valid interpretive rule? What does it have to be a valid interpretive rule?
Not binding until, through the regulation.
Well, an interpretive rule, theoretically non-legislative rules are not binding, but interpretive rules can be binding. Why?
Through the regulation.
Because the overarching law is binding, not because the interpretive rule is simply interpreting what's already out there. So the question is it merely interpreting what's already out there, or is it adding additional requirements, remember? Now, with those two ideas in mind, if either one of those are true, it is a legitimate non-legislative rule, excuse me. If neither of those are true, then it needs to go through notice and comment rulemaking. So what do you think? I think this is a hard question, by the way. If it makes you feel better.
Let's talk about getting a farm and
Okay, what does it specifically direct regulated entities to do?
3 backup.
3 backup things, right? Can you find that requirement anywhere else in the existing statute? No. So it cannot be a valid interpretive rule. All right? Can it be a policy statement? Does it have present effect? Or is it something that the agency is going to do in the future and allows agency decision makers to change their minds? Takes present effect, right? Okay, so it cannot be a valid policy statement, it cannot be a valid interpretive rule. Therefore, the answer is D.
You made it harder.
I did. Well, I made it harder, but I also, we'll leave it at that. I made it harder. Sometimes you write things into questions that you may not be aware you're doing. So I have to change things around often. All right, question 5. By the way, before we go any further, honestly, there were how many of you in the class? 24, so I should have had 12 questions from 12 groups. I would say of those, maybe 6 actually followed the directions perfectly. I don't get that. I don't get that. So I tell you this now because that's the #1 issue on exams, is you don't actually read them. You don't tell me what I'm actually asking for, you don't have to read the question. So if I can do nothing else today, and actually the bar exam has the same thing on it, read it. Actually answer what's being asked. Do that for me, okay? Because that is a stupid way to lose points on your exam. It's not to actually answer what the question is, and it happens every year, okay? All right, sorry, this was one of the ones that didn't have enough options, and that's why it created that issue in my head. Okay, so this should automatically jump out in your head. We've got a mixed question here, right? At least from the answers, if you read the answers. So let's break it down. First off, what is the agency action here? What did the agency do? I'm sorry? Yeah, at one point it made a regulation. Is that the thing that's being tested?
Informal education.
Okay, but let's just start back at what does it actually say it did? We'll figure out what it is in a second.
Oh.
Says on our legislation.
Interpreting its regulation.
It says okay, so just if you'll bear with me, it says DOL issued a letter. Okay, so we're all there, right?
Mm-hmm.
So first thing, make sure you identify the correct action that's being analyzed. Because yeah, the agency also promulgated regulations. Well, that would be a different standard. So you want to make sure you have the right thing. So it's the letter that's being challenged. All right? What is the letter doing?
Interpreting its own regulation.
Interpreting its own regulation.
So it's our.
Right. So our is the second piece of it, questions of law. Now my guess is most of you would have gotten that wrong because you didn't break it down slowly like that. Okay, that's why I wanted to take it very step by step. You would have immediately seen that it was a regulation and gone straight to Chevron. Or you would have said, oh, it's a letter, hence it must be Meade. But no, it's an agency letter, informal adjudication, as you said. But because it's within the informal adjudication, it's interpreting its own regulation. That's an hour deference standard. So what's the first part? Do we have arbitrary and capricious or substantial evidence?
Has to be arbitrary and capricious.
Right, it's informal. So the correct answer would be, I believe, E. Okay, does that make sense?
So,
Everybody with me? All right. Question 6. Mercer Department against fund.
Yeah.
Oh, I like this one too. You guys are very clever.
None of these.
You guys only provided 4 answers, though.
I did read the instructions, I just thought I would remember it from business associations, and I didn't.
No, we only had 4 in business. I have 5 in admin.
That's why.
Just to confuse you. All right, what's the answer? No clue, huh? All right, well, we've got 2, right? Let's start with the communication with Cossack. Can a decision maker communicate with investigators about sort of status updates?
No.
No?
That's-
They could.
Okay.
Yeah. Yep. All right. Then we have the decision maker contacting a party to ask about a factual question. Does that seem right? No. So the correct answer would be what? B is correct. Now notice what I was telling you earlier. It's not just that it's ex parte, it is impermissible ex parte. So notice the way that I wrote that question, or answer I should say, okay? By the way, I had to throw in E. Sometimes, particularly when you have 5 choices, it can be hard to think of a 5th one. And so I was just trying to come up with something that would completely throw you off to think, oh, well, that's true, the rules of evidence don't apply, but it's completely irrelevant to the question. So don't let those things trip you up. They're usually true statements, but that have nothing whatsoever to do with whatever the question facts are. Okay, 7. Do you see how talented and creative your classmates are? I didn't ruin it. I fixed it.
See? She mushed it, I don't know what's it.
That's another reason why we go over them. It's not helpful to you if you give me questions and then I completely change them and you don't know what the answer to your own question is.
Okay.
You do actually know what the answer is.
So like, can you ever like go back and like show me what was wrong with my question? Cause it like, it might have something to do with my understanding of the material.
Perhaps. Want me to talk about it later?
That's
All right, what's the answer?
E.
E. You knew the answer. See? All right, now why did they're mad at me because I changed their answers. I don't even remember what they were testing on, but the E was the answer they had provided. But one of the things we went over in class was the whole concept of whether an agency's inaction on a petition was going to be reviewable. Well, if you weren't in class, like some of the people who aren't here today, you might well think, well, you know what, that's right, there is no agency action. Maybe it's not reviewable, that would make sense. And so part of that is to test at something that I talked about in class, but that was, it may or may not, I think that was in the reading, but I'm not sure it was really clear in the reading. So I changed that question to address something that I will often test on is things I say specifically in class that aren't necessarily forwarded if you don't attend class. But yeah, agencies have to take an action on a petition, and so that action is reviewable. Other agency inaction may not be reviewable. Okay, good. Question 8. And this is another one, I did the same thing. I took something we talked about in class, and I wrote it into the answer. So, see if you can find it this time. Nope, thank you for catching that.